Morning, everybody. Welcome to the third and final of the 2021 Subsidence Forum training webinars. I hope you're all well this morning. My name is Sarah Dodd. I am the chair of the Subsidence Forum this year. I am not speaking today, you'll be glad to hear, so I will hand over briefly to Patrick Isaacs, who's the chair of the Special Interest Training and Education Group, to do the introduction. So over to you, Patrick.
Thank you very much, Sarah. Good morning, everyone. It's another great turnout, so many thanks for your continued support. First of all, we're obliged to confirm our compliance with the Competition Act, and you can see there our usual statement on that, and I'll leave you to read that at your leisure. So welcome to the Subsidence Forum Training Day, final part of the trilogy for 2021. As many of you will know, we've run webinars for the last 2 weeks in place of the more usual in-person event that we historically have put on in October. Obviously, COVID prevented that this year, last year as well, but the webinars have been a good alternative and have proved very popular. We've had around 150, 200 people register for each of the first 2 webinars, and it's about the same today, which is a fantastic turnout. So once again, thanks for your support. The forum exists for the benefit of its members, so the more people we can attract from all different aspects of the subsidence industry, the better. So today's the final webinar for this year, and we have a talk about statutory tree protection from PRI coming up. That was due to be followed by InsurTech Insights talking about building your brand and social media, but I'm sorry to say their presenter hasn't been well all week and is unable to present to us today. We will make good use of the extra time, and we've invited back some of the presenters from the earlier webinars to take part in an extended Q&A session, which will happen following PRI's talk. So we have Paul Duddle and Matthew Newis from Abbey Pinford ready to field any queries regarding drainage and underpinning. Sarah Dodd spoke last week about the Environment Bill, and she'll be available to field any questions on that. And of course, PRI will also be around to answer any queries regarding their presentation. In addition, we have the Subs Forum past chair, Ron Mace, ready to chip in as and when required. So please use the Q&A button to submit any questions that you may have, and we'll collate these and ask the appropriate expert to respond, all following PRI's talk. We should have a good 10, 15, 20 minutes ready, available for questions, so please keep them coming in. And we aim to wrap up around 10 o'clock, give or take a few minutes each way. Now, if you missed the first 2 webinars, then don't worry, they're recorded and can be viewed on the Subs Forum website or on our YouTube channel. And in fact, the webinars from last year are there as well. So there's lots of good training material available for your perusal, all free of charge. Finally, there'll be a quick survey at the end of today's session. Please take a couple of minutes to complete it. It will help us plan next year's events, whether we have more webinars, more Q&A sessions, perhaps an old-fashioned in-person event, or maybe a combination of all 3. Please let us know what you prefer and what you'd like to hear about, and then we'll try and provide something to suit. So that's all from me. I'd now like to introduce the one, the only Mike Lawson, Chief Exec from PRI, who's going to keep us royally entertained for the next half an hour or so, talking about statutory tree protection. Mike, over to you.
Okay, thanks, Patrick, and thank you very much to the Subs Forum for inviting me on to talk about this topic, which is an important one for us all. I was having a little chat with the organisers beforehand, and we wondered whether or not me being on mute for 40 minutes might be a benefit for all the people watching, but we've decided to give it a go. So what I want to do is think about statutory protection in a historical context, and and think about how we get to that idea of the city salubrious, the movement towards a green and pleasant city and urban spaces, full of the amenities that include urban trees. And also I want to take a little look forward through the statutory lens at where we might be heading in terms of a climate changed world, and how we might deal with some of the contradictions around amenity trees going forward. Next slide, please. So one of the key points in law that evolved over many decades is that an Englishman's home is not his castle. We have property and we have title boundary, and there is that sense that within my own space I am the master of all of I survey. And of course that's not quite true. In the United Kingdom we have very strict planning controls which guard what can be done on land, and that may or may not be weakened or has not been weakened over the last few years. But the truth is we have one of the most comprehensive planning environments in the world, and our national and statutory local authorities have many ways in which they can control what happens on land. And we have building controls that flow from the planning controls to ensure that the standards applied and any conditions applied are properly discharged. We also have land charges. We have that charge over the land. And in this particular image, I wanted to give that sense of the section through the title. If we think of this parcel as a title boundary, then what we should remember is that land charges apply to the title boundary. That's really important when we start to talk about tree preservation orders. There's a little debate you can have, a little sit around a table and ask how many trees in the United Kingdom are subject to tree preservation order, and a facetious answer would be none. There are no trees covered by tree preservation order. Of course, right now our professional tree officers are all wondering what on earth is he going on about. Parliament in its wisdom determined that the charge over the land was of the land for its amenity benefit, for the benefit of the space to have that tree in front of us, above the ground and below the ground. And it is the land that is the subject of the charge, not the tree. Parliament was very wise in thinking this through, because what they realised was that a tree preservation order could never survive the death of the individual tree, but a land charge over title could mean Parliament could order replacements. So the idea of a title boundary, and I want you to run a little exercise with yourself. I want you to find as many tree preservation orders as you can and have a look at the nature of the order. And you'll find the nature of the order must comply with its service in title. It must comply with the boundary. And this creates that, of course, that natural paradox that the roots of the tree that stray beyond the title and the branches that stray beyond the boundary are strictly not controllable under a tree preservation order. And again, I've had people dispute this, but I've sat in front of technology court judges who've confirmed that that is the case, and with some of the most senior legal counsel in the UK who've said that is the case. As a land charge, the preservation of the tree must go with the title parcel. We have covenants. We can have covenants of all kinds that restrict activity that might go with the title deeds. Thou shalt not have, Thou shalt not have pigs in the house or on the ground. Thou shalt not cut down any tree. And we can have things like Section 106 agreements, etc. But the main basis of statutory protection would flow from our planning controls in conservation, and in the land charge that would flow from a conservation position. And then there's also the public amenities, which kind of wraps up all of these things. And the public amenities of vegetation can go both within the land and without the land, i.e. visual amenities of a well-treed area, make it more salubrious, make it more attractive. Human beings appear to like to live in places in and around trees. And we see that in property land values. There is a direct correlation between well-balanced, well-treed areas and property. And we'll tend to see the concentration of the tree preservation orders in those locations. One of the things I wonder about is that are tree preservation orders a form of control and a form of approach which is very class-based. I wonder if we spend our money and we like to go and make the TPOs in the conservation areas, and we like to go and manage them, and the well-lined streets and gardens and the beautiful areas. And I wonder whether or not the same, if we were to look at the resources used, whether the same amount of resource at the same percentage level goes into areas that are less well treed. And I think that one of the things tree preservation orders do is they tend to concentrate our mind in particular locales that are already well provisioned. So I think that's just a debate that could be had. So you are lord of the title boundary of your land, unless it's unless, of course, you've a mortgage, and then the mortgage company will have a relationship with your title boundary. And that's all. The rest of it is all up for grabs. Next slide, please. So looking backwards, how did we get to the point where an Englishman's home was not his castle? If we think of way back 1,000 years and right through the medieval, right into the modern age, basically cities were concentrations of places where work and where profit could be maximized, and very little thought was given to the impact of pollution and of the nature of our cities for the good of the inhabitants. If we go back in time, if you think statutory tree protection, from the last 1,000 years of English law invariably involved chopping off the hands of the citizens if they went near woodland or went near trees. A great part of statutory protection was about commoners not going anywhere near anything pleasant, which was reserved specifically for royalty. It wasn't until well into the 19th century that things had got so bad and health of our communities got so bad that city planners started to wrestle with the concept of a healthy city. Cities were dirty, dangerous, smog-filled, disease-ridden, dens of pestilence, and human lifespan short. It's interesting that when you look at human lifespans through the Victorian era, human beings should live for about 70 to 80 years. They do in subsistence, and they do in other communities that have not modernized. And in actual fact, when you look at the crashing values for human lifespan, it was principally because so many children died. It was very hard to live in cities and be a child. So childhood birth rates and then death rates were so high that human lifespan as an average started to shorten. There's no reason in any part of this planet you shouldn't live for 70 to 80 years. Next slide, please. So from that sense of the Victorian engineers, the great engineers who built the marvelous infrastructure taking away human waste, and began to build our water supplies, clean water supplies from the great building programs in the Welsh Hills, City of Liverpool, City of Manchester, Sheffield, the great reservoirs that were built and the pipes that were laid that brought the clean water. There was a movement that began to appear, which was, there must be more. There must be more that we can do for our people than simply give them their health. And of course, as the engineers improved sanitation and the science of statistics proved these benefits in health and lifespans, some pioneers started to lift their heads, and the thought was of the public amenities flowing from the city salubrious. That idea of public amenities, of all of the value that accrues. Amenity essentially is all of the positive values that accrue. There is that sense in the TPO legislation of visual amenities, but in essence, by protecting the visual amenities, you are concentrating the other values, wildlife, pollution control, etc. But these innovators began to think about cities that could do more than simply house a workforce. And of course, this started to come along with things like emancipation, you know, the idea of the ordinary vote for the ordinary man, and then the idea of the ordinary vote for the ordinary woman. We even allowed that as we moved forward. The idea of pleasant places, of parks, of gardens, the idea of time that wasn't work, of amenity time, began to concentrate minds on those spaces that we would occupy. Next slide, please. Now, this is a lot of text, but we don't really need to concentrate on that. What we can see here is the evolution of those thinkers, those great thinkers, and their impact in the movement for garden villages, which was a really important part of that urban development history. As employers and industrialists made so much money that they were heaving with wealth, they had enough time in their wonderful estate houses in the countryside, surrounded by beauty, to think about how they might make their poor, mean workers' lives somewhat better. And so we began to have that movement towards labour as not simply a resource for capital to plunder, but as something that was of its own right, a human right for green space. And so all of these, you can go away. We've given you the list there. Robert Titus Salt, George Cadbury, the Lever brothers, Joseph Rowntree. These were the really great thinkers at the time. But they did do that from a position of great strength. They were thinking of their workforce, and they wanted a healthy, happy workforce from the position of strength of their wealth that they'd amassed. Other garden city pioneers, Barry Parker, Raymond Unwin, the developments at Letchworth, 1903. And of course, what this produced was various schemes of management. And even today, you have this duality of the garden suburb trusts and the Dulwich estates and their role within a statutory framework of tree preservation orders. So there is an interesting framework there that's sometimes at odds with who's in charge here. So there was that whole idea of a city salubrious, a path to reform for people. And as we moved into the 20th century, work began, foundations were laid, and we started to move forward towards the idea of the garden suburbs. Our suburbs were to be places that the people could relax. Next slide, please. And of course, as our cities grew and as garden cities appeared, then we had to connect them, and we had to connect them far more effectively because of the automobile. And the rise of the automobile gave us the rise of the highway. And the Highways Act, specific powers, Section 96, powers of the highway and local authorities to plant trees, lay out grass and verges. There is that sense within highway provision that they shouldn't simply be utilitarian. In fact, there is that direct sense that they should assist in terms of calming a journey and in fact improving the health of those on a journey or pedestrians who have a legal right to use the highway. So we must think about that idea of the Highways Act as part of this constituency of statutory controls. Next slide, please. So we have that sense of the private estate and the fact that an Englishman's home isn't his castle, and then we have the highway estate, and then we have the parks and the cemeteries and the public spaces and public shared buildings that have grounds around them. A point that the Act and Parliament envisaged, that no tree, shrub, grass, verge, guard, whether planted or erected under this section, will be allowed to remain in any situation such as to hinder the reasonable use of the highway, or so as to be a nuisance or injurious to the owner or occupier of premises adjacent. Parliament always wants to have a way to manage conflict. Other council managed trees will operate primarily within the common law, neighbour to neighbour. But for the Highways Act, I think it's very important we recognise that Parliament rarely just says it's all good. It's rarely all thumbs up. Parliament is very wise in thinking about how would we resolve conflict. And the Act allows that conflict to be considered and then managed. I know that Sarah's done a great deal of work on the new statutory frameworks that are coming forward, but they will only supplement the basics of how our statutory law and our common law interacts together in terms of the rights of a landowner, private landowner, to not have nuisance from a third party, whether that be private or statutory. Next slide, please. And of course, as we began to expand our cities, the idea of those areas that were of particular historical importance, our conservation areas, began to appear. And the conservation area, of course, is primarily associated with building quality, with the quality of a particular area in terms of its historic buildings. It's always interesting if you look at the reasons for making a conservation area, always go back and have a look and ask the question, did they even mention trees? But as we know, those trees that are within a conservation area have the power of the Act behind them. And if upon notice in a conservation area of the intention to fell a tree, the council are given a period of time in which they can consider the making of tree preservation order. Now, it's important here to notice that when you apply to remove a tree in a conservation area, you're not applying, you're not making an application, you're notifying. You're notifying the council of an intent. That intent has a 6 weeks duration. And if under that period of serving of intent, the council determine that they don't agree, then they have the power to make a tree preservation order. They cannot allow the 6 weeks to lapse and expect the protection to remain. They can decide not to make an order and allow the lapse to occur, at which point one would expect that the person who'd made the notification would move to remove the tree. Next slide, please. And then, of course, we move on to the making of that order, Tree Preservation Order number 9, 2020, Tree 1. There it is. And the council has that power if it appears to the local planning authority that it's expedient in the interests of amenity. There's that word, amenity. And that's primarily considered to be those visual amenities to make the provision for the preservation of trees or woodlands in their area. And I want us to all focus on that concept of the tree is now within a land charge. And a land charge makes provision for that tree to be registered by the council on that land and any subsequent heirs to the space, any future tree planted at that location under any application. Over many years, I've done many audits of tree preservation orders, portfolios for local authorities. A little interesting one for any tree officers on here would be to go and audit your tree preservation orders and to find out how many trees are no longer there from the first creation, if we go back to say the 47 period. How many of the trees are still in existence, the actual tree? On many of the audits we did, up to 70% of trees had been lost with no application made. Just an interesting thing there about this idea that local authorities believe that the tree preservation is there and they'll stop people, catch people. Well, I can only tell you that when we did audits, we had levels of up to 70% of trees no longer existed, and there was no evidence there was ever an application made. And one would expect that, an attrition. Is that criminality? Probably not. Ignorance, an awful lot of that. But certainly I would always start with audits. I'd want to have a look at my TPOs and I'd want to see exactly how they're matching up to their value. So the tree preservation order is a charge, a land charge over the land, and it makes a provision. And remember, as a local authority, you're making a provision for the likelihood that there may be financial loss to the council. Within the registration, obviously an applicant can make an application to fell. We now have application, not notification. And that application has with it the risk that if the local authority refuse, that there will be a charge against the council for any loss that then occurs as a result of the refusal of consent. So the making of a TPO is a really serious matter for a council. I always ask about the policies that committees have agreed that give power to officers to make such orders, and the landscape context, the landscape character context of why orders are being made. Not simply it's a tree in a garden, not simply there are trees that are available. It's on the basis of is there a policy framework and background in which the tree should be preserved by the council. Next slide, please. Okay, so one of the areas, obviously, for the Subs Forum is the whole issue of subsidence claims, and a hugely vexed topic over. I've been involved in subsidence claims now for 31 years and have been called every horrible name by many people to this day. And I fully understand the vocational calling of tree officers, and I fully understand why communities would want to retain their trees. But we do have a really powerful safety net in the United Kingdom, a safety net called general insurance. And general insurance as a safety net protects people from those misdeeds and those problems that can occur. As example, they protect people from flooding risk. They protect people from total loss in fire. They protect people from internal problems of escape of water or smaller fires. And they protect people by way of subsidence. And it is a contract made between a general insurer and a member of the public to protect the asset, the mortgage asset, often a mortgage. So where we have a mortgage, then we have people who have liabilities to a lender and liabilities under the value of that property. And a general insurer cannot seek to frustrate the selling of a property on the basis of a claim against the contracted policy. If you think about of the above slides, you see a a real smorgasbord of controls of the city tree. For me, the evidential standard should be really simply to determine, and unfortunately it isn't. What we should be able to do is to move very quickly through, what do you claim has happened? What do you claim has happened? I claim that my property has rotated and moved downwards. Can you evidence your claim of what has happened? What is the nature of the evidence to your claim? Is the evidence independent and impartial? Many people will say loss adjusters and consultants like you, Michael, can't possibly be independent. It's simply untrue. It's just untrue. We have no prior knowledge. We have no reason other than to try and identify causation. Over many years, I've seen multiple audits of insurers and others of loss adjusters, and a little interesting one. I remember a while back an audit that was done. More than 95% of first notifications of loss, the loss adjuster correctly identified causation on the first visit without any evidence. And I believe that's true. Other people won't. I believe that's true. So what is the nature of the evidence? Is the evidence independent and impartial? Are the providers of the evidence experienced? Are they chosen by an insurer because they understand the issues and they have great experience in the particular claim type? And have they provided a suggested remedy to the issue of causation? So we have had mandatory evidential requirements from, I think, 2012 for TPOs, which reflects just these points. It reflects all of those points. But of course, it's in the human interaction of those points that we have conflict. Next slide, please. Why isn't it straightforward? As a technical question, subsidence is straightforward, but it's not just a technical issue. Trees form part of the city salubrious and they're alive. They are totemic for many people. There is a huge emotional component for the public and for the officers that are charged with their management. Even in the courts, I can tell you that when you stand, and I've stood on the stand many times and be questioned by all the major barristers who would run this type of case in a court, judges love tree cases. They're fascinated by them. You know, it's interesting. It's very interesting. So there's a huge emotional component. Councils have duties to perform. I mean, on the insurance loss adjuster side, I would say, remember, I've always said they have duties to perform. They have a statutory duty to protect. So we can't expect them to just roll over. We need councils to fulfill their duties on behalf of the public in a democratic way through a statutory vehicle. To implicate a tree ascribes liabilities, particularly Tree Preservation Orders or Highway Act. In the statutory sense, you have now a provision which councils have to retain against future liabilities. I'd ask any young officer to go and ask finance what provisions have been made, funds that are being retained against future claims against the council. Money that could be used for schools, for gardens, for parks, has to be put to one side. A land charge, a charge over the land in both directions, liabilities for all. But liabilities have costs. And where there are costs, conflicts of interest emerge. Now, I know that Sarah covered in terms of the arrow pointing more and more towards public intervention of decisions on tree removal. I don't think, for me, it changes substantially the framework that I've just discussed. We know that the costs of investigating, mitigating and repairing claims is going to rise as we wrestle with net zero. Remember, I'm going to be absolutely clear about statutory tree protection. The cost of underpinning would break any net zero plan. Concrete, metal, movement is costly, hugely costly. And I expect that recovery costs will rise, and they could rise against councils who are going to be strapped for cash. Now, these aren't things that I hope for or wish for or believe are inevitable, but we have to think about them. Next slide, please. So one of the things to think about is have a little mind map. This will be available afterwards, but literally from your own purposes within local authority, think about claim origination, not from a loss adjuster's perspective, but as a council, and try and follow the thread. You know, what is the significance? It's a tree preservation order, but is it a very material tree? Why can't we fast track? So let's imagine an apple tree, rear garden. It's covered by an old area order. It's covered by a group order. Just happened to get thrown in there. It's 40 years old. It's 3 meters away, and the conservatory is rotating down towards it as a result of a very hot summer. Is that a tree that we should be fighting hard, tooth and nail, to retain when we can have a replacement planted? You can't just make every tree a cause celeb for a battle. You need to have a mind map of how you will manage, and this is our own internal mind map of how we manage yeses and nos through a process. Next slide, please. Okay, so 10 years time, and then 20 years time. I just thought I'd play with my crystal balls. There you go. I just thought I'd play with a few ideas and a few things we can think about. I would think that by 2030, the UK will have breached 42 degrees on a single summer's day pretty regularly. Maybe we'll be in an economic boom post-Brexit, and with Boris in charge after another couple of landslides. And an economic boom with the Tories leading the charge on retrofitting for net zero is in full flow across the planet. UK GI insurance premiums have risen sharply as the true cost of climate change begins to impact rates, to get more expensive to insure for the future. Continuing specialist manpower shortage in claims management, causing delays to how claims are fulfilled, with so many more cases appearing. The public purse under continuous stress due to the impacts of the pandemic borrowing cycle. And I guess we still haven't agreed what is a reasonable evidential standard for a substance case, or how we would constitute an application through a fast track, a medium track, and a slow track to appeal, or otherwise for claim against a council for a refusal of consent. I think that's likely. I think I've been 31 years, and I'd challenge everyone here. I mean, I'm afraid in 31 years, we're still just throwing complaints at each other and blame at each other. And we don't sit down, and we do not talk reasonably, and we do not consider the matters on a reasonable basis. And I think we should be able to. We owe the public a duty of that if we're going to move forward. Next slide, please. So coming full circle, some 2 centuries since human beings began to really focus on the mess we'd made of the environment, here we are again, focusing on the mess we've made of the environment. We've moved from a mess to city engineered and through the city salubrious, and we now stand on a precipice. Future claim management will need to make its cases ever more strongly. That's true. We're going to have to be very clear, very precise about what it is we think we're going to do. Investigation needs to be prompt, effective. We'll need less visits, more use of remote sensing, more desktop triage, less time in the car. We'll need better mitigation, remediation, and repairs. We'll need to be challenging claims that start to move towards net zero management. And that'll mean a full carbon balance approach to controlling substance and less partisan flag waving. So are we all up for the challenge of that? And I can understand that people who wish to protect every tree would say, let's protect every tree, have no tree in Britain felled as a result of a subsidence claim, and underpin everything. Do you really think that's reasonable? Do you really think that insurers can bear that cost, that premiums can bear that cost, and that net zero could cope with all that concrete and all that metal going into the ground at a time of great crisis? Tree management will continue to involve tree removal, and we need to start to challenge ourselves how we get that net zero carbon balance within our claim management for our loss adjusters. And I challenge the insurers and loss adjusters to think about the challenge of a net zero claim managed. Thank you very much for your time, and I hope you've enjoyed this talk.
Thanks very much, Michael. We have had a couple of questions that have come through on the Q&A. Mike, if I can ask them to you, if that's okay. You may have covered a couple of them off as you've spoken, but I'll raise them independently as well. Yep. So Simon Fulks has asked about group TPOs. So he said, hang on, let me just move the questions over here. He said there are group area TPOs, and these move on from specific boundaries of a house. So where does the law stand on this subject, where the tree roots will extend to other properties, for instance, where the entire area is covered by the group order? Yeah,
it's one would expect. So there's an interesting point here of the extension of title, as you would know, Sarah. Does the original serving of the order encompass the various title parcels? So one of the things that we typically have in the planning process is that we have a range of TPOs made before on let's say, a new development proposal. And then, of course, we have the final title boundaries added. Well, that doesn't really matter because those title boundaries encounter the land charge. So in a situation where tree preservation orders cross boundaries, I would I would always expect they would have been served on multiple landowners, and through the searches process of new properties becoming available, that the solicitors would have searched and uncovered the presence of the land charge, the TPO, even though the original map may not show the physical red line boundaries now. But where a group of trees grow beyond the boundary onto new title, there is no protection. There is no protection whatsoever. And so that becomes quite vexed when you look at accuracy, particularly in new build situations where your original order might have been made at one particular granularity, and now the land title has changed. You might find that the boundaries don't match up. So I'd always say, personally, on a new build scheme, once the houses have all gone in and you found out how bad the developer's been at keeping the trees, God bless them, that what you might do is go back in, revoke all of the original group style orders and reserve orders on that basis would be my best advice.
Interesting, talking about house builders. As a solicitor, we often deal with small snippets of land which weren't handed over as part of the highway, weren't included as part of the homeowner's boundary. And I don't think perhaps some house builders realise that 20 years later they still own 2 square metres of land which have had a tree growing on it, which they didn't know existed and haven't ever done anything about. I've come across a couple of those.
Yeah, vexed. Land of unknown ownership, or land of can't find who they are ownership. And of course, Sarah, once you know as well as I do, once you begin to post a notice and say, does anyone in the community know who owns this land because it's causing subsidence, the silence is deafening. No one wants to then put their hand up and say, I mean, a very famous one, Sarah, we had was a case where a enclosed area of wire mesh fencing had trees within it, and there was a clue with the fact that it had the water board's name board on the gate with contact details, and the trees were causing subsidence. We asked them, and they said, of course it's ours. Well, as we pursued the reason, they said, we have no records on our system of that particular site, and we do not believe we own it, even though there was a sign that said, this is ours. So people will be very quick to run for the hills if they think they may be on the hook for something.
Moving on now, there was a couple of questions about the joint mitigation protocol. So Giles Carter said that the joint mitigation protocol was an excellent concept to speed up decisions on local authority trees, but it's lost momentum for a variety of reasons. What needs to be done to reinvigorate and roll out wider adoption across local authorities and insurers?
Yeah, I think there's two parts to that, aren't there? There's, first of all, is revisiting it and be wonderful to have a group of like-minded, sensible people who could at least be civil to each other to check it and update it, make sure it's still fit for purpose. But really, there's a big problem, I think, in that the nature of local authorities. Let me give you an example. You're a local authority out in the sticks, out in the shires. You don't really see a huge amount of subsidence problem. You don't come across it a great deal. It's hard to get these things in a busy day embedded as policy and protocol. You're a London borough, North London borough. It feels like the Third World War. You're getting hundreds of applications a year. And it's costing you a great deal of money. It's hard to be balanced about the impacts and the pressures you're under. So I think on the one side, Sarah, we need to have the forums such as the Subs Forum talking about the joint mitigation protocol. That needs to be with people who have an independent frame of mind. But also I worry about the monies that we've taken out of management in local government. I worry about the lack of resources, the pressures they're under. And that will tend to, you'll then start to see outsourced claims management, which I'm not against at all, but can then tend to create a confrontational environment. So taking the heat out of it as professionals would be one excellent way forward. But I do worry that the mitigation protocol is hamstrung by the lack of investment in our local authorities.
Yeah, and those are points that I would echo as well, Michael. And I remember when I did my the Environment Act session last week, and I made a comment that had come from something on one of the government's websites, which was the government will make sure that the local authorities have all the funding they need to deal with this appropriately. And I almost knew in saying that was going to be an incredibly inflammatory thing to say. It was an easy comment to read on a website, but I'm sure the local authorities are thinking we'll believe it when we see it. And
I'm not in local government, and it's inflammatory to me, Sarah.
Yeah.
So it's quite outrageous. After 10 years of the money that we've taken out of local government and the added commitments we're asking them to manage in terms of housing and health and immigration, we have to spend more on our local places and spaces. City salubrious is one thing, but that we have not even begun, Sarah, to think about climate change and what's going to happen. And the reason I was so keen to do that, our housing stock is simply not fit for purpose to face continental style summer temperatures for weeks on end. There will be a real impact, and our urban forests are going to be frontline in trying to reduce by a few degrees that. Now, people then say, how can you then move to say you would fell a tree? I come back to my whole thesis that there is a commitment under contract to protect equity in a property and the rights of a private person. But that doesn't mean the two things are at odds, that we've a massive challenge to green our cities and local authorities who are impoverished.
No, yeah, I totally agree. I know that you were mentioning there about you know, putting some proper time and resource into this, and I know that Subsidence Forum has spoken to the London Tree Officers Association about doing some work on the joint mitigation protocol. So hopefully that is something which will. Patrick's nodding there and said, yeah, that's something that we are committed to doing. Kieran Hart's made a comment that he was recently involved in a claim with the London Borough signatories to the joint mitigation protocol who wouldn't acknowledge its existence, let alone work to the timeline or the evidential requirements within it.
Well, the idea of not even acknowledging its existence, that's a nice start, isn't it? I you know, on both sides, I would say, take the heat out of this. There's make your case, refer to it, put your application in. Remember, let's be clear, an application is made under TPO, an 8-week period proceeds, and then the council refuse or allow it to move through. They are on the hook. They are on the hook on behalf of the community for any loss associated with that refusal of consent. Now, there are people who would say, literally today, still after 31 years, say to me, I don't believe trees cause subsidence. Now, that's a fanciful attitude which the courts will never support. Trees do cause subsidence. And once you've refused consent, you are making a commitment with the community's money at a time of great stress. And I'll make another point that's something that really is challenging us in insurance. People's ways of living have changed. Lots of people are suffering mental stress. Is it right that we will allow statutory periods to protect an individual tree to so stress the occupant, the owner, their families at a time of enormous stress where people have been confined to homes, and yet, Sarah, resources have been taken away from local authorities so that they can't adequately deal with the caseload? So this is a massive issue, which I think can only get worse unless we do something fundamental as professionals.
Another change in tack slightly here, Michael. So Giles Carter's asked another question, saying he recalls that RSA had their own woodland for replanting in the noughties as a way of offsetting subsidence tree removal. Is there still a similar initiative at RSA or other insurers? And if not, should the Subsidence Forum host one?
Oh, wouldn't it be wonderful? I believe, you know, the idea, if you think now, Sarah, you can go on an app, a website, and you can offset your own holiday by contributing to planting schemes, etc. I would think, Patrick and the rest, I think a question for us, I come back to what I said, how do we move towards net zero claim management by 2050? Well, surely there is a role there to say, what would be the most effective? I really would say, Sarah, who would help us decide how we could best mitigate where with tree planting against the costs of subsidence that occur in terms of tree loss? And I believe it's possible, and I believe it's passionately that it can be done, and I believe that insurers would be delighted to have it included in their CBES biennial stress test of how they're dealing with climate change issues. So I think there's a real forum for us here, Sarah, to get something going that can do some good.
And I know that I've spoken to some insurers in the past who perhaps sponsor entities such as the Woodland Trust. Yeah, and I would say over the last 12 months, with my sort of lawyer's hat on, I'm starting to see questions like this being asked, which is, you know, if this tree is being removed, what's the insurer's policy on replacement planting? So that's something we are going to see and hear more and more because of the carbon and the biodiversity issues there. We got another couple of questions, Michael. So I'm conscious that we've only got a few minutes left. So I'm going to see if I can squeeze in these and get you to answer. So Simon Fuchs again has asked, would you say that the Town and Country Planning Act is perhaps no longer fit for purpose and needs a major update by the government?
Yeah, answer yes. 1990.
1990, yeah.
Yeah, there's a clue. Oh, 100%.
Yeah. Yeah. And Patrick's actually asked a couple of questions here. So, hi, Michael, what's your view on the effectiveness of tree root barriers? And actually linking onto that, would you need to submit a TPO application if you were, sort of linking onto that, if you're piling within, say, 10 metres of a protected tree, but that could be piling or perhaps installing a root barrier?
So first of all, let's deal with the easier one. Piling within, say, 10 metres of a protected tree. Well, it's your duty to know whether or not you might have a breach. So you're working near a TPO tree, take advice. That advice might include for some ground excavation to check. And then you have to make your own mind up. You have to say, what do I think? Now, it's perfect. I've done it many ways, Sarah. Had a chat with the tree officer, got him outside and showed him the work that we planned. And he said, I think it's de minimis. I don't believe you need an application. Very concerned about this. Often, not because of the piling within 10 metres, it's the work pattern of equipment, Sarah. It's what you have to bring on site that can cause you the problem. But I would say the answer is yes and no. I'm sorry, you might have to submit an application based on the tree and the circumstances of site, and you might not have to submit one. On the other one of root barriers, not a fan because of something I said before, title. The problem I have with root barriers is, first of all, they have to be so extensive, so disruptive, so costly in excavation and return across multiple title boundaries that then become a problem, Sarah, a conveyance of memory, maintenance. I've seen many root barriers fail. Now, does that mean never? No. But does it mean know your circumstances? Lots of space, heritage tree, country pile, can get in easily, not multiple title boundaries, maybe. Now, some people are very wedded to the idea you can use them, and I don't mind that. Some people use them as a first response. I don't mind that. But don't underestimate the health and safety, legal consequences, climate consequences, Sarah, of digging out all that soil, of using the heavy equipment 2-3 meters down, and then inserting the geotextile. Don't anyone believe it's a nice, easy, well, why don't we just stick a root barrier in?
Yeah. Michael, I've got a question here. I'm skipping through the questions because I've just seen one here from Simon Nash. So a highway tree officer for a large Midland city. And he's saying, generally, we act and remove our trees which are implicated in subsidence claims. Our policy is to replant in the same location as there is a research for suitable replacement trees, but also could the insurer work with us on this and may use this to help offset their carbon footprint?
Again, Sarah, what a great one to roll in of public-private partnership. To, why does the replacement planting, the loss? One of the reasons I said think carefully is I'm not so sure I want to see us planting in the Amazon rainforest, which may be very laudable when the trees are being lost in Dudley. So I think that officer should really come forward and help the committee with how local authorities and insurers can actually work together going forward. There's one there I've noticed from Giles Carter, are covenants legally enforceable? I'm going to be really rude, Sarah, and say no. This has been held in the Ombudsman has said, if a council wishes beyond covenant section 106 or condition to retain a tree, they should make a tree preservation order.
Yeah. Any other things cropping up in the chat box that you want to answer?
I'm also, I've got one here I think is lovely. My understanding is that severing of roots could also be a breach of the TPO. If I sever the roots within the red line title boundary, I agree. If I sever the roots outside the title boundary in the land charge, what would be the nature of your prosecution? So Sarah, let's do it. You did willfully, let's go before the court, Sarah, that you did criminally, with willful intent, remove the roots on your own land for a land charge that stopped at your boundary. I'm wondering how much laughing the judge would have before he didn't criminally prosecute me. It's not going to happen, and everyone can say, if the branches and roots, if you cut them, I'll say to any officer, I'll tell you what, pick your TPO, we'll go along in the garden, and I'll take a pair of secateurs and cut a branch over the boundary in the opposite garden outside the title, and you prosecute me. I'll do it in front of you. You photograph me, you've got the evidence. I'm really meaning it, Sarah. It's not rational.
Well, on that bombshell, Michael, I think I should probably draw us to a close. So thank you very much for your really interesting session today. That was certainly thought-provoking and entertaining. So thank you, Michael and PRI. So I'll just take this quick opportunity to close off this year's Subsidence Forum training set of webinars. I would really like to thank all of you for signing up and attending, those of you watching now in real time, and obviously those of you who are watching later on catch up on our YouTube channel, which I'm really excited about us having. Thank you to all the panelists and demonstrators who've spent the time to put together a really interesting set of presentations this year. So thank you. This year, again, we did this free of charge to really encourage people to attend that aren't perhaps members of the Subsidence Forum, but I would say that the debate and the questions that have come through have really made for interesting discussions. So if you'd like to continue to be involved with that discussion in the world of subsidence, then I would encourage you to pop onto our website and consider joining as a member for the Subsidence Forum. A benefit of the Subsidence Forum is that you have attendance at these sessions. There are executive sessions. It's a forum for discussion and raising issues. And also we co-wrote the Subsidence Forum handbook. So don't forget that's still in existence. You can pop onto our website and purchase a copy of that if that's of interest. At the end of this session, there's going to be a feedback form. There's a new question on that this week, which is talking about a potential new special interest group. I mean, both Michael and myself have spoken a lot about the environment and how things are going to change with net carbon zero, and how that's going to implicate insurance claims, insurance premiums, and how things are managed and how repair works are done. So a thought is that a special interest group could perhaps be set up to start addressing those really topical climate issues. So if you are interested in that, then please do give that feedback on the feedback form. But that's all for me, really. So thank you again for everybody attending. I really hope you've enjoyed it and you found it useful. And I will see you next year, if not before. Thanks, everybody.